Anything further, Ms. Waldrop?
Nothing at this time, Judge.
Counsel?
Good morning, Your Honor. Mike Hawkins for Mr. Ferguson. Judge, my understanding is we are here on a motions count. We have a number of motions that were filed back on October 26, 2021. We also have, because there was such a delay in the case, a plea and bar and motion to dismiss based upon the violation of defendant's constitutional right to a speedy trial that was filed last December, on December 5th. My understanding is that we're here on those motions. That's what the notice for today indicated. And by the way, I did find the attachment that she sent with the offer. So she did send us an offer. What that email included was on Monday, her making me aware of her intention to request transfer of the case. And I asked her yesterday if she would send me a copy of the order she provided you, and she was kind enough to provide that to me. So I've reviewed that order. I want to point out two things, Your Honor. First, that is a 2021 case that she has mentioned. July of this year, so in 3 months, that will be 3 years old. Okay, it'll be July 2024. It's now towards the end of March of 2024. No mention of this transfer has ever been raised here. This case essentially has been sitting somewhere for 4 years and going on, I believe, 5 months, 6 months. And that's why we filed the plea and bar in December. Her motion to transfer now is being raised orally, as I understand it, where we've had written motions that have been filed over 3 years ago. And so, or well, 2.5 years ago, I should say, Your Honor. So our announcement this morning is ready. We are ready to hear the evidentiary motions, which includes a motion in limine to exclude defendant's statements and acts, a motion in limine to exclude all evidence based upon an unlawful seizure, a motion in limine to exclude any evidence of chemical testing. All of those have been filed and served October 25th, 2021. And of course, the plea and bar was served about 4 months ago, 3.5 months ago. And so the state has been on notice that this motions hearing has been scheduled for today. So Judge, our announcement is ready to move forward with the evidentiary motions, including the plea and bar and motion to dismiss. I would point out that Mr. Ferguson and his mother have come down here, drove 2.5 hours from Cleveland, Tennessee. That was his home at the time of this arrest. That has been his home throughout this process. That is where the court has given him notice of these. As such, in Cleveland, Tennessee, which is a smaller town in Tennessee, I don't believe that he'll be qualified for Fulton County's DUI court or even a transfer. I know that we transfer cases here locally between DeKalb and Forsyth and so on and so forth. So our announcement is ready to go forward.
And Judge, if I may, respectfully, Judge, this is an order from state court, and it's specifically for the reasons that defense counsel even stated. While this 2021 arrest is 3 years old, there's no indication at this point that any treatment has been done. So we don't know what it is the defendant has done to address the substance abuse issues. That is the purpose of the DUI court division. With respect to him living in Tennessee, that does not preclude him from entering into a DUI court program. The DUI court division is specially equipped to find programs locally for defendants that they can attend in their specific residential area and jurisdiction. So that is also part of DUI court and what they do. They will reach out to local DUI courts in order to get someone into treatment. And it typically will be something that is the equivalent of what they would provide here. With respect to the plea and bar that was filed, Judge, I just want to point out that that was not asserted until December 5th of 2023. Defense counsel has filed at least 3 leaves of absence in this case. If the court looks at the record, so to assert that at this point, you know, the purpose of DUI court and transferring it there via Judge Edeline's order is so that they can handle this case from top to bottom. That means they will handle the motions, they will handle entering the getting the defendant entered into treatment, if that is what he so chooses to do, and they will handle any trial of the case and they will fast track it for the purposes of resolving the case faster than what we could do here. So.
It's my understanding that you have to be accepted into DUI court. That
No, Your Honor. So with regard to that order, it does not have to be voluntary. It does not have to mean that the defendant can decline the treatment program. It is just dealt with by the DUI courtrooms. So Judge Edeline and Judge Taylor.
no, what I'm saying is that you have to make application to be in the DUI court, and the DUI court has to accept you as a participant in their court.
Right. They would, yes, you would make application and they would need to accept you. If you don't, they handle your case.
There's a distinction between the treatment program and actually the courtroom itself.
Right. So you want to explain what you know?
Yes, Your Honor, there's a distinction between the 24-month treatment program and these cases being on the docket in the DUI courtroom. And so it's up to the defendant whether or not he would want to enter into the 24-month treatment program. But even if he chooses not to enter into that specific treatment program, the DUI courtrooms are better equipped to handle these cases.
Okay, I think you all are missing my point. My point, I think, is that you have to make application. You just don't say, I'm sending him to DUI court. You have to, prior to going to DUI court, ask the DUI court if this is a case that they will accept with it in their court. And if they accept it, that's one thing. If they don't accept it, it stays with.
That's not my understanding, Judge. If you look at the order is clear that cases in which it would constitute a second conviction in 5 years or a third or more in lifetime, it goes to that division to be handled there. So it's not my understanding that I have to contact DUI court. And I have been in contact with a prosecutor, Mr. Hollins, our ASG in DUI court, but that's not my understanding. No, not from that order. They are equipped to handle cases that are multiple arrests and convictions.
I'm going to take a recess. During my recess, I want you all to, if you haven't discussed whatever offer's been made, to discuss that with your client. If I can get a hold of Judge Edeline, I am going to, because our understandings differ. I'm not sure if you're right. I'm not sure if I'm right, but as many times as I've done this, there's always been a request of the DUI court that we just don't send cases to them, that they have to accept them before they're actually transferred to them. So there has to be some type of application process made so that they can accept the case.
And there is, and I sent over the referral form as well in my email to defense counsel. So it is referred to that division. He will then apply for DUI court. He'll go to an orientation and all of those things and determine whether or not he wants to enter into the 24-month treatment program. If he declines that program, there is an offer, a non-accountability court offer on the table for it, specifically if he declines that program. But the point is that all of that is done within that division. So there are two judges, Judge Edeline and Judge Taylor, who oversee that. That's my understanding of it.
Who sent me this case? Do we know? What division did it come from? Okay.
And Your Honor, I don't know the answer to this. I'm convinced because he is not an Atlanta, not a Georgia resident, that there is not going to be transfer as an option for him to this DUI court. And if I understand the state's argument, what they're saying is none of that matters. The standing order requires, if I understand their argument, the case to be transferred pursuant to that order. Again, Judge, and I don't mean to repeat myself, we were placed on a motions calendar, an evidentiary motions calendar for the motions that we filed 2.5, 3 years ago. And then in addition, the plea and bar and motion to dismiss that we filed in December. So our announcement continues to be here and ready. I guess what I would ask is, if I'm accurate that DUI court is not an option that's available to an out-of-state defendant, where does the case go from there? Does it stay in the DUI court? Does it come back to you? Or does it go back to Judge Morrison, which was the original judge? We were arraigned by Judge Morrison back in 2021. On the notice, Your Honor, and I have a copy of it here, it indicates that we are to report to Judge Morrison. But of course, we got a notice to come see you in G33 today, and here we are for this motion. You actually set this motion down in December, or perhaps January. And the last thing I'll say is this, Judge. I think I'm right on this. Not once has this case ever been set on my leave of absence. I heard the state argue in relation to the plea and bar. I'll make the court aware, I'm required to file leaves of absence as I serve as a part-time judge in the Dunwoody Municipal Court. A statute was passed 2 years ago stating that any part-time municipal court judges must file a leave of absence for their other cases in order to serve as a part-time judge. This case has never been called on any court docket, whether it's arraignment, motions, trial calendar, anything, where my leave has caused this case to be continued, not once. So I just want to make clear on that issue if the state is raising that at this point. But I think that you're accurate, Your Honor. The initial determination needs to be, does this standing order require you to transfer this to Judge Edline, to Judge Taylor? If that's true and he's not eligible or not a candidate because of he is a Tennessee resident, I just would like to know, what does that mean? Does that mean we come back to you? Does that mean we go back to Judge Morrison? Does that mean that it stays in the DUI court? I think that's an important question I would like to know the answer to.
Well, it's my understanding that if he is not accepted into the DUI court, it's going to come back to me.
And that's what I'm telling the court is my understanding is it stays up there and it fast tracks through their program. It doesn't mean that he necessarily enters into the 24-month treatment program. And that's the distinction that Mr. Birch was speaking about when it came to DUI court.
Okay. I'm going to take a recess. You all discuss, if you haven't had the opportunity, what offers exist, and then we'll discuss it after the recess. Let's see. Is there someone is somebody else? Y'all can have a seat. You're fine. Did someone join me on the Zoom call that needs my attention?
Your Honor, Cameron Salee here for Scott Smith's office. I believe I'm just making an announcement for the case in Desmond Pham. I think we withdrew our motion, actually. It was on schedule for tomorrow. Just making an announcement that we will be ready for trial.
Okay, so you want to be placed on the next available trial calendar? Is that what you're telling me, counsel?
Yes, Your Honor.
Okay, that trial calendar will be in June.
Yes, Your Honor. Understood.
Okay, so we'll place you on that calendar and I'll see you back in June.
Thank you, Judge. May I be excused?
Yes, have a good day.
Likewise.
All right. Court stands in recess. Okay, court will come to order. I've had the opportunity to speak with one of the judges that's over DUI court. It is both my and her opinion that I am not required to transfer this to the DUI court at this time. I will just place it on the record that this case was placed on this motions calendar a number of months ago. At that time, which has been at least 2 or 3 months ago, everyone was informed to be ready to go forward with these motions today. I will hear these motions this morning. And after hearing the motions, if I decide that the case goes to DUI court, I'll assign it to DUI court, but I will be hearing the motions this morning. Were you all able to make any progress as far as possible settlement of the matter?
Yes, Your Honor, we had a chance to speak. I just want to speak with Mr. Rhodes real quickly.
Okay, all right. So
Stand by.
court will be on recess until you all are ready to proceed.
Y'all need me just holler, okay?
And Judge, the state is ready to make a brief announcement. in the case.
Okay,
Okay, so Your Honor, with respect to this case, it is my understanding that defense counsel is challenging a few things, a couple of issues. The first and foremost being reasonable articulable suspicion, probable cause, from what I could see of the motions that were filed, as well as voluntariness of consent to the blood test in this case. And so we have the Trooper de Gorville, who is currently with GSP. He's present and ready to testify to those things. It is also my understanding from the motions that defense counsel is challenging the nurse that drew the blood, as well as the GBI toxicologist that stored and tested the blood. And so that GBI toxicologist is Mr. Duriel McKenzie, who the state does have on call and has been in contact with. With respect to the nurse, the state is unable to go forward and proceed on that particular issue today. The nurse is Miss Candace Smith of Grady. We did our due diligence in, sending a subpoena to Grady. We did not get a response. We attempted to pull the license of Miss Smith from the Secretary of State's website, but because the name is so generic, Candace Smith, there are several. And so with respect to any challenge to Miss Smith's drawing of the blood, the state would be requesting just a brief 1-week reset. We think we can get that information to the court in that amount of time. I understand that defense counsel doesn't want to piecemeal the motions, and so we would be prepared again within that 1-week reset to be able to go forward on all of defense's motions and get that information with respect to Ms. Smith. I do want to put on the record that the state had a good faith basis that this case would be transferred to DUI court today per the standing order of Judge Edeline. And so if the court is not prepared to do that, then state would be requesting just that brief 1-week continuance to be able to address the issue of the drawing of the blood by Nurse Smith.
yes, counsel.
Judge, on behalf of Mr. Ferguson, our announcement continues to be ready. The court indicated earlier, this case has been scheduled for motion for several months now. Both parties were aware of this. The notion that this transfer might take place first arose on Monday evening, when the state essentially said that that's what their intention was to request this. I would object to any continuance, particularly, Judge, since the state has been forthcoming in stating that Ms. Candace Smith is not under subpoena. Now, Your Honor, it is in your discretion. I can pull up the statute under, I believe it's Title 24, that indicates that where there is a party requests a continuance, that they must demonstrate that a witness is under subpoena. If the witness is not under subpoena, there are lots of lawyers I've heard argue that say that you are required to deny whichever party is requesting that continuance. I've read the case law, it's in your discretion. But I would ask the court, since this case has been on for several months, and also given the age of the case, that these motions have been filed since October 25th, 2021, including our motion to exclude any evidence of chemical testing. The state has been on notice since October of 2021 that we intended to challenge this evidence. They've certainly been on notice, as you indicated. We both have been on notice since the court scheduled this motions hearing several months ago. I'd like to point out that Mr. Ferguson is not a resident of the state of Georgia and came down here with his mother to hear these motions, and we are prepared to go forward with all of our motions today. I do agree, and I mentioned to the prosecutor that hearing some motions today and some motions next week, I don't have this case on my leave of absence or my conflicts for next week. Those are additional grounds for me to object. So I would ask the court to deny the state's request for a continuance, as they've been put on sufficient notice, as we have. My client has come here from out of state and we've announced ready. We would ask that the motions go forward in their entirety this morning.
And Your Honor, I just want to state one brief correction. I believe defense counsel cited section 17-824. That's not the appropriate section and not the correct section. It's 17-825 with regard to absence of witnesses as grounds for a continuance. And I do want to inform the court that that section specifically deals with trial. It says it in the article, chapter 8 trial, Article 2 continuances. That deals with trials with regard to having witnesses under subpoena. I do want the court to be aware of that. And so that would not apply here. This is a motions hearing. And so the state would request a continuance.
Mr. Hawkins, just so I'm clear, you'll be proceeding on reasonable suspicion, probable cause, voluntariness of consent. What are the issues?
Judge, we have those issues that have been indicated. We have a separate motion in limine to exclude the horizontal gaze nystagmus test. We have a motion in limine. Sorry. To exclude chemical test results. And Judge, if I might, if you look at our motion in limine to exclude chemical test results, if you look at paragraph 2 and paragraph 4 of that motion, we specifically put the state on notice that it is our position that the state must show that the defendant's blood was drawn by a qualified person pursuant to 40-6-392A2. So they have been placed on notice in that motion regarding chemical test results that we specifically intended to raise. And the blood drawer is on their list of witnesses, Judge. They just have not been able to subpoena her for today, and they're not able to show that. And so to request a continuance regardless of statute for a witness that the state has failed to subpoena, I don't think is sufficient grounds given the rest of the totality of the circumstances with Mr. Ferguson coming down here from Tennessee. But we do intend to go forward on all of those motions.
All right, I'm going to put everything into a written motion, but at this time, the state's request for continuance is going to be denied. Call your first witness.
Do you want to talk any further or no? Yeah.
Court will be in recess. Okay, I believe we're ready to go back on the record. Good morning, Mr. Ferguson.
Good morning, sir.
Can you raise your right hand for me? Do you swear affirm the testimony you're about to give before this court to be the truth, the whole truth, and nothing but the truth?
Yes, sir.
Okay, you can place your hand down. Thank you, sir. Yes, Ms. Waldrop.
Yes, Judge. This is position number 1 on your calendar this morning, State versus Andrew Ferguson. Mr. Ferguson is pleading to 1 count of reckless driving and 1 count of failure to maintain lane. This is a negotiated plea, and the Senate's recommendation on the reckless driving is 12 months to serve 1 day, credit for time served of 1 day, balance probated, for Mr. Ferguson to pay a $1,000 fine, complete 240 hours of community service, risk reduction, an alcohol and drug evaluation and any treatment deemed necessary, as well as a victim impact panel, and to have ignition interlock installed on his vehicle, which it is my understanding that that is currently installed. With respect to the failure to maintain lane, the Senate's recommendation is 12 months, credit for time served of 1 day, balance probated, and that is to run consecutive to the reckless driving. We did agree that after completion of successful completion of 12 months of the probation, that the ignition interlock could come off of the vehicle and that probation could go non-reporting for the remainder of the 12 months. Counsel, do you stipulate to a factual basis, venue and identification for purposes of the plea?
Yes.
Nothing further from the state judge.
Hawkins?
Your Honor, this is a negotiated plea. We would ask the court to accept the terms. As you recall in our pretrial discussions, Mr. Ferguson is a resident of the state of Tennessee. We're requesting that he be allowed to report by phone or mail, that he be allowed to complete the terms of his sentence where possible, risk reduction online, victim impact panel online, and I will assist him with finding acceptable community service to complete the 240 hours, but we would ask that he be allowed to do that closer to home in Cleveland, Tennessee. Judge, he did get a second charge. He has completed the terms and conditions of that sentence with no violations. He is currently, essentially, as I understand it, due to a clerical error, he was eligible to have the ignition interlock device removed, but because it had not, and I'm kind of, just paraphrasing this, because of a clerical error, he wasn't credited for 1 year of that in Tennessee. So he is eligible soon to get that removed. That's the reason why it's still on there. I asked him why, now that we're 2 years past when he completed his sentence, is that still on? He does share with me, and his mother is here, that he has never had a probation violation on that sentence and has never had a reading that caused any violation on the ignition interlock. So I think he's a good candidate to complete that and the rest in terms of his terms and conditions of his sentence without violation. And we ask the court to accept the terms.
Mr. Hawkins, it's my understanding that in case 21 CR 005553E, you wish to plead guilty to reckless driving and failure to maintain lane. Is that correct?
Yes, sir.
Are you under the influence of any drugs or alcohol this morning?
Sure.
You have to
Little
speak
bit
up
loud.
for
I'm sorry,
me.
just a little bit
I'm
loud.
sorry.
It's being
No, sir.
recorded.
You've been represented by counsel. Are you satisfied with his representation?
Yes, sir.
You understand that you have a right to a trial by jury on these charges, and that by pleading guilty to them, you're giving up your right to a trial by jury?
Yes.
Has anyone forced or coerced you to plead guilty?
No.
I'll accept the plea as negotiated. As far as the probation goes, whatever's acceptable with probations, it's fine with the court. So as far as how he reports and what he does, as long as that's fine with probation. We should have given you where you need to initially report to probation. I ask that you do that within the first 2 weeks or so.
Okay.
Okay. Anything further this morning?
We had just filled out the form. We have not yet received instructions on what he needs to do. So we'll remain until we get instructions on how he needs to connect with probation.
Okay, very good. Good luck to you, sir.
Thank you, Your Honor. And Judge, that's all I have. May I be excused?
Yes, good to
Thanks,
see
sir.
you. Okay, do we have anything further for this morning that we need to take up?
I do not believe so, Judge.
Okay. Ms. Hammond, thank you so much for your help today. We appreciate it.
You're welcome. Have a great day.
All right, you have a great day too.
You too.
Okay, I will see you all tomorrow.